Ladies and gentlemen, I'm really pleased to introduce this panel. This is the kind of panel that only the panelists could really convey the information, because it's an extremely important area of the law, and it can be a complex area of the law, and it's an area where policy is really developing. I'm hoping to hear from our panelists what their views are on that. Our moderator is David Hoffman, who co-teaches a course with Chris, Professor Chris Schroeder, who's on our panel. But David's other job, so to speak, is he is the Director of Security Policy and Global Privacy Officer at Intel Corporation, and he is a graduate of Duke Law School. So we're very, very pleased that he has agreed to moderate this. He'll introduce the other members of his panel, but I did want to highlight one of our panelists. She worked for me when she was on active duty, and I promised her I would not embarrass her with this year, as I've done in the past, because yeah, and I'm just going to leave that up there for a few seconds as she reddens. I remember when she sent me this photo when she was deployed, and I didn't know she was in Afghanistan at the time, and I wasn't real happy, but we've become great friends since then. And more recently, she was briefing the vice president. I think this was just in the very, very near past. Yeah, she's just acknowledging that. Anyway, back to our panel. David?
So the yeah, exactly. It's a great honor for me to be here, and Charlie, I want to thank you so much for allowing me to moderate, to be here at my alma mater, and to be at this particular conference with all of you. It is fantastic, and I'm deeply humbled by that, particularly given the expertise that I've seen over the course of this conference. I'm fortunate in that capacity to have the panelists that we have here today to dig into this discussion. Sitting at my right, Professor Chris Schroeder, the Charles Murphy Professor of Law and Public Policy and co-director of the program in Public Law at Duke Law School. Chris has interrupted his career here at the law school several times to serve in the government, most recently spending close to 3 years as the Assistant Attorney General at the Office of Legal Policy at the Department of Justice. Prior to that, as Assistant Attorney General in the Office of Legal Counsel at the Department of Justice, and prior to that as Chief Counsel of the Senate Judiciary Committee. Sitting to Chris's right, Erin Wirtanen, as already introduced by Charlie, but there's a few other details that we might want to describe, is the Principal Litigation Attorney with the Office of the General Counsel at the CIA. You saw that she was an active duty JAG officer in the Air Force and served overseas both in Saudi Arabia and Kuwait, and also spent several years working for the State Department in Africa, in Zambia and in Kenya. And to Erin's right, Greg Nojheim, Senior Counsel and Director of the Project on Freedom, Security, and Technology at the Center for Democracy and Technology, is a world-renowned expert on cybersecurity law and the Fourth Amendment, sits on the Department of Homeland Security's Data Privacy and Integrity Advisory Committee, and previously was Associate Director and Chief Legislation Counsel at the ACLU's Washington office? Yes. Great. So let's dig in a little bit. There's a lot here, and we have designed this to be as interactive as possible. We're going to get to questions hopefully relatively quickly from the audience and then keep building from there. I did want to frame this a little bit, and I changed my introduction completely after hearing Ben speak. I actually think the theme of this panel should potentially be, what should grown-ups worry about? So, let's assume we're all going to be grown-ups, and then let's really ask the question, what should individuals worry about with their personal data, particularly when it's being held by the private sector or by government, and how are those interests different? I loved the example of cyborgization. Then at Intel Corporation, which does not stand for intelligence, unfortunately, it stands for integrated electronics. We tend to see a theme evolving that technology in general is becoming two things. It's becoming more personal, and it's becoming more connected. So whether you deem that to be cyborgization, but not only is that technology becoming more personal to you as an individual, but all of that technology is becoming connected. So it's not only just reading things from you, but it's reading your relations to other people and other devices, and it's also having the ability to apply advanced data analytics technology against all of that information. So as technology becomes more personal and connected, what does that mean for us? And once again, coming back, what should grown-ups really worry about? So there's a lot of people who go out there and say, well, you know, if you have nothing to hide, then you have nothing to worry about. It's a very common theme. A couple people have, Dan Solov, professor at George Washington University, has written a whole book on that subject. I have found very compelling a more recent book, an analysis by Professor Neil Richards at the Washington School of Law on what he calls intellectual privacy. And so you can think that, or you can consider that as technology becomes more personal and connected and data analytics ability increases and becomes more robust, what organizations really get an opportunity to do is not just see your behavior, not just see your communications, but actually be able to understand what you're thinking. And what are the implications of organizations understanding not only your behavior and your communications, but actually being able to predict and take actions based on what you're thinking is something that has not been fully considered and is not covered under the law as it's developed since the 1970s, as Ben was describing. So let's take the pacemaker example really quickly, and I want to play with Ben's example just a bit. Assume that it's not just that you have the pacemaker that's delivering some level of metadata or observed data wirelessly, but you're given an option when you get it. You can take the option where that data stream just goes to your doctor, and they're going to charge you $100, or they're going to charge your insurance $100 a month to operate that service on an ongoing basis. Or you can take the option to have all of that data sent to an organization, we're going to call it the Big Data Corp. And they're going to use the data however they want, because that's what their privacy policy says. If anybody would ever read it, Greg would probably read it, but I don't know whether anybody else would read it. But that's going to be free then. And there are, I think, interesting implications then of what does that mean for individuals when a private sector organization would have access to that data? What are the implications under Smith v. Maryland and the third-party doctrine? What would the implications be if government then got access to that data? So I want to use that as a place to launch into more discussion. And we said that each of the panelists were going to take a few minutes to start and laying out the issues, and then we were going to come back into questions.
Great.
Professor Schroeder.
Thanks, David. Just to lay down a couple of points here at the outset, I got into this set of issues that we're going to be talking about most intensely when I was working at the Justice Department back in the first term of the Obama administration, where one of my responsibilities was to head up an internal working group to try to figure out how, if the administration had its druthers, it would propose amendments to some of the surveillance-related standards for law enforcement, not the IC side so much, but law enforcement that had been on the books for a long time and clearly had been showing their age. I'm talking about the Stored Communications Act and the Community Assistance for Law Enforcement Act, the details of which I won't bore you with. But suffice it to say that after about 6 months of working on this very hard with a working group that was composed of people from the Criminal Division and the National Security Division, because national security is involved in all of these issues now at the Justice Department, regardless of what they might be, as well as the DEA and the FBI and so on, I suddenly found myself the representative to an interagency working group on the topic. And I wasn't experienced enough now to tell you that what I know then, to tell you what I know now, that was the death knell of anything getting done in the administration, because the interests being represented around the table were so multifarious. But one thing that struck me about them was there were a lot of people there from the Commerce Department, from the United States Trade Representatives Department, from the State Department, OSTP, the Office of Science and Technology Policy, the Council on Economic Advisors. And my first reaction was, what are all these people doing interested in law enforcement surveillance? Well, of course, the reason they were there is that because commercial data collection and data privacy issues and law enforcement and intelligence gathering issues have become so intertwined that it's impossible to deal with any one of them within a government, all of government framework without this incredibly unwieldy group of highly disparate interests. And the immediate cause of concern of Commerce and USTR and those folks, of course, were the negotiations and the efforts we're making to sort of sync up the EU's understanding of what constitutes adequate commercial data privacy protection with ours and our intelligence gathering priorities. Because if you talk to anybody from the EU, whether it's Germany or other countries, they are quick to criticize the lack of meaningful constraints on government access in the United States to data as an argument for constraining the ability of U.S. corporations to obtain EU citizen data to use in their commercial enterprises. And since the EU is the second largest economic concentration in the world, denying that market to American companies on the grounds of a rule that the EU may eventually put in place that places restrictions on the moving of EU citizen data to the United States would be quite devastating to some very large economic interests and the most robust section of the American economy, the e-commerce and internet-related concerns. So at step one, these issues of commercial data privacy and government data privacy are intertwined in a way that was just really brand new to me as someone who hadn't been in government at the Justice Department since the Clinton years, but it was obvious to see that this was a tremendous sea change in the 15 years between the two times I served in the Justice Department. The other thing that struck me about the commercial data privacy issues, and really a lot of this came from working with David on the course we teach on commercial data privacy and government surveillance, where we're trying to understand the connections between these two, is, on the one hand, how much data gathering and manipulation there is in the commercial sector, and on the other hand, how relatively lower the sense of anxiety and consternation is among the population about the activities that are occurring in the commercial sector. So the data gathering and analysis is absolutely extraordinary to me. The FTC did a report on data brokers last year in which it reported that one of the leading data brokers had 1 trillion records on the behavior, the buying and selling behavior and other information on U.S. consumers. Another one claimed to have 3,000 data points on average for every American consumer, which must extend well beyond, but includes places they had go to purchase various goods and services, websites they had visited, personal information, personally identifiable information, which may or may not be getting stripped out of various data analytic procedures that are being used. And you can't pick up a newspaper on any regular basis without seeing at some level a report of another data breach on the part of a major corporation like Home Depot or Target or Jeb Bush's political campaign. The data breaches are vary enormously in their magnitude and their significance, all of which have potentially as devastating effect on people's finances and the information that the corporate sector has about us and the manipulations they are able to make in order to draw conclusions about our purchasing behavior. That's what data analytics in the commercial sector is fundamentally about these days, predictive analytics to try to figure out what kind of ads to push out to you that are going to be successful. But as David's introductory hypothetical points out, we are entering an era in which the digital exhaust that all of us cough out in our daily lives is just growing exponentially, and the uses of it currently are about as unlimited as the imagination of the individual companies or startup concerns that might have access to that information, which again is made readily available by this network of data aggregators in the commercial sector. So there's lots to say about the comparisons between the degree of controls that are in the commercial sector versus the degree that are in the government. I suspect Erin's going to say something about the government side, so I'm just going to stop here and look forward to talking about this more.
First, I just want to thank you all for having me here, and especially General Dunlap. Even though you've embarrassed me and I'm still bright pink, I really, am I red? Great. Good to know. At least I matched my ribbon. But I'm very grateful to be here, and Professor Dunlap has been an awesome mentor for me, and so thank you again for having me. As I am currently with the Central Intelligence Agency, Office of General Counsel, I just want to make it clear that any personal opinions I give are those of myself, and not necessarily official views of the Central Intelligence Agency or the Office of General Counsel. With that said, I think that Chris teed up the argument or the analysis very well. Really, we're at an area and a time where we have to balance between national security and privacy interests. And the balance isn't so clear, and it hasn't been quite legislated like perhaps it could be or should be. But I think that given the technological developments across our society, we really need to have a more comprehensive context for this discussion. So if I told you that every tweet you'd ever tweeted on Twitter has been recorded and archived and is publicly available, would that bother you? And would it bother you more if I said that it was done by the intelligence community or by a private corporation, or, as it truly is being done, by the Library of Congress? The answer to that question is very telling for how we view these things. A couple of other examples I'd like to present to you in the private sector. Would it bother you if you were walking into a public building which had facial recognition technology, took a photo of your face, and then used massive databases of information to gather information on your criminal record, and maybe even links to databases that contained your average annual income? Again, would it bother you more if the intelligence community was doing that, or would it bother you more in the private sector? That example is also true, and it's being done by the casino industry. Although they do report a 10% accuracy rate right now, the technology will improve. Yes, I love the example that they gave of they were looking for a Caucasian male, 6 foot tall, and it matched with an African-American lady who was 5'3". So there's ways to go still with that. What about if I told you there are high-speed cameras that exist? They're not only mounted on vehicles, on stop signs and street lights that record thousands and thousands of license plates per minute, and then correlate those license plates with huge databases of information. Would that bother you to know that that was occurring? And in fact, that is, again, a true occurrence which is happening in certain areas, by local law enforcement, but more recently by private corporations. Private corporations are gathering this data and selling it to law enforcement. Now, there are some states and local laws that are now gaining speed to prevent or limit or reduce the amount of data that can be gathered in this means, but it's continuing to be an issue that needs to be looked at. What would you say if I told you that every single keystroke you make on the internet is being recorded and archived? Petabytes of data being recorded and archived. A petabyte, by the way, just by analysis, or analogy, is 1 petabyte is 20 million 4-drawer filing cabinets full of text. There is currently an Internet archive project which has had 16 petabytes as of December 2013. The current size of the collection is unknown, but it's much more massive than 16 petabytes. All of this information is being kept and held by private entities who are working on these archive projects. So note to those law students who are hearing me, I'm sure in the overflow room, those vacation photos that you post and delete, somebody can look at those later on.
This is very timely advice on the eve of our spring break.
So, Leslie, what would you say if I told you that third parties have collected information on you from your name, address, marital status, religion, occupation, all the way to your weight, dress size, annual income, health issues like if you have depression, anxiety, insomnia, and even things like hepatitis, HIV. And this information is currently being collected by big data brokers. The premise of this discussion was the intelligence community is collecting all that data on Americans, I think you all would be up in arms and be upset by that premise. But here we're talking about private corporations who are collecting this data on you, on the average American, and selling it to the highest bidder with very little regulation and very little oversight into what they can collect, how they can collect it, and how they can disseminate that information. All this is sort of leading me to my ultimate premise, which is that the information that the government has and collects in general is more highly regulated. There's statutes, there's of course the Constitution, which despite what people might say about NSA, we all do in the US government do appreciate the Constitution, but there's plenty of laws and regulations that limit the collection that the government can do and put restrictions on not only collection, but dissemination and use of information as well. So let me kind of go into some of those real quick. I think the one, while I certainly can talk about the Constitution, I know Greg is a constitutional scholar here, so I'm going to pass on talking about the Fourth Amendment and leave that for his discussion. But obviously it is something that the government cares about in the collection of data. But let's talk about what I think you might be more interested in is FISA, Foreign Information Surveillance Act. FISA, really there's four parts of FISA that I want to talk to you about generally. I'll start talking to you about, well, let's talk about FISA generally first. FISA was passed in Congress in 1978 and was significantly amended in 2001 and 2008. It regulates electronic surveillance and other activities carried out for foreign intelligence purposes. FISA provides limits on how the data can be collected, retained, how long it can be kept, and disseminated. There is oversight on the FISA process to ensure that the rules are being followed. So FISA, of course, has a special court called the FISC, the Foreign Intelligence Surveillance Court, FISC, that hear applications by the government to conduct electronic surveillance for foreign intelligence purposes. Since FISA surveillance involves acquiring content of communications, generally, it implicates privacy interests that we all have. And because it implicates privacy interests, it also implicates constitutional interests as well. So the four types I'm going to talk to you about briefly is first traditional FISA, Section 215, Section 702, and 704. So traditional FISA is really two parts. Electronic surveillance is Title I. Title III is physical search. And really traditional FISA applies to intrusive collection inside the United States, regardless of the target of the collection. So regardless of the status of the target of the collection, which could be a U.S. person, a U.S. citizen, or not. Under traditional FISA, the U.S. government is required to demonstrate there is probable cause to believe the target of collection is a foreign power or an agent of a foreign power. An example of this would be if a known terrorist was in the United States and the U.S. government knew he was a member of a group engaged in international terrorism. So let's take this analogy back over to Section 215. 215 refers to Section 215 of the Patriot Act, which was passed shortly after 9/11. Really, under Section 215, the intelligence community is allowed to apply to the FISA court for an order requiring the production of documents or other tangible things when they're relevant to an authorized national security investigation. Records can be obtained only if they're the type of records that could be obtained pursuant to a grand jury subpoena or other court process. In other words, when there's no statutory or other protection that would prevent the use of a grand jury subpoena to obtain them. Even with these parameters, the President has recognized public concerns about this program, Section 215, and ordered several steps be taken to put some constraints on it, essentially. First, except in emergency circumstances, the government must now obtain the FISA court's advance agreement that there is a reasonable, articulable suspicion that the number being used to query the database is associated with specific foreign terrorist organizations. So let me back up for a second and sort of give you an overview of how the applicability to my example before about a known terrorist. Really, it's to receive and obtain call data records, telephony metadata, essentially. So it's not content of communications based, but it's based in metadata of duration of phone calls that called, the number that a phone call made phone calls to, duration of call, time and date of calls, but not actually the discussions that occurred during those phone calls. So it's metadata solely. The second step the President took to limit 215 was that the results that an analyst gets back from a query are limited to numbers in direct contact with the query number. So if we know a known terrorist is using a phone number, we are limited now to collect on 2 hops instead of 3. So the known targets, known contacts, we can only go 2 steps out, essentially. Section 215 will expire or sunset on June 1st of this year. And there are some proposed solutions to this to maintain this type of collection. Most notably is the USA Freedom Act, which is still pending before Congress. So let me go to a couple of other areas, Section 702 and Section 704. Section 702 of FISA generally applies to collection inside the United States, targeting the collection of non-U.S. persons located abroad. So, for example, this might be a known terrorist who's located overseas, who's a foreign person, who might be using, for example, an U.S. email provider to communicate. Under Section 702, the U.S. government is required to demonstrate that there's a reasonable basis to believe the target is a non-U.S. person outside the United States, and the collection will result in the acquisition of foreign intelligence. This reasonable basis standard is more lenient than the probable cause standard under the traditional FISA, where we talked about the target being located inside the United States. Section 702 is beneficial because it creates a streamlined process in order to accomplish electronic surveillance against the non-U.S. person targets overseas. And lastly, 704 really applies to collection conducted outside the United States targeting U.S. persons. So, for example, if we have a known U.S. person who moved to Syria and has joined ISIL and is engaged in terrorist activity, then we could get the U.S. government could receive a 704 authorization to collect information on that U.S. person. All of this FISA that I've discussed is subject to minimization procedures, and minimization are generally procedures that are approved by the FISA court and must be reasonably designed in the light of the purpose and technique of the particular surveillance to minimize the acquisition and retention and prohibit the dissemination of non-publicly available information concerning unconsenting U.S. persons, consistent with the needs of the U.S. to obtain, produce, and disseminate foreign intelligence information. So I realize I've taken a little bit more time than I was supposed to, but let me just end with talking very quickly In addition to FISA, the other thing of interest, I think, is the U.S. government must comply with Executive Order 12333. 12333 EO 12333 is what you'll hear it referred to. And this order is pretty much the fundamental charter of the intelligence community. It provides additional limitations on what the intelligence agencies can do. It defines each agency's responsibilities and authorities. And as it pertains to U.S. persons, Section 2.3 provides, and I'm going to quote this because I think it's important, elements of the intelligence community are authorized to collect, retain, or disseminate information concerning U.S. persons only in accordance with procedures approved by the Attorney General after consultation with the Director of National Intelligence. That's the end of the quote, but these procedures have to be consistent with the agency's lawful authorities. They have strict limits on collection, retention, dissemination of information about U.S. persons, unless that information is of a foreign intelligence value or in certain circumstances involves a threat to life. So at the end of the day, what I'd like for you to get out of what my comments have been so far is that there are a lot of restrictions on the U.S. government's collection, retention, dissemination of information. There are not as many limitations or little to no limitations on the private sector retaining, collecting the same information, or if not more intrusive information on U.S. persons. And so I think it's something that we, as an American society, need to evaluate our comfort levels with the private side collection of information with no constraints versus the government collection of information, which there are constraints. However, I understand, and I know this is probably a point Greg will make, but that it is a little more worrisome to some degree when the government is collecting any information because of why do we worry more about the government collecting information? It's because of the power the federal government has, right? The right to grant licenses, to audit your tax returns, to prosecute and incriminate you. However, these constraints are being rigorously applied, and they are being done in the most ethically consistent way. So with that, I'll turn it over to Greg.
So Greg, maybe you'll just agree with Erin, and then we can talk about the Duke-Syracuse game tonight. You know, is there something here that grown-ups should still worry about?
I think so. Maybe something. You know, I listened to all that, and then I said, well, okay, what's the reality at the end of the day? Mm-hmm. The reality at the end of the day is that the phone call that I made to my wife this morning to say everything was fine, the email, David, that I sent you to say plane is running late, all these things somehow are relevant to some investigation and are eligible to be collected by the NSA and held for a time that the NSA determines itself. I don't see how all the things that are in FISA, I mean, how do they amount to a hill of beans if that's the reality at the end of the day? And it is. Now, I wanted to start, though, with a way to look at the commercial side and then translate that into the government side. I look at it, there's three buckets of information that are being generated. One is that which you put out to the public, that which you tweet to the world, you want everyone to see it. With respect to that data, if somebody's collecting it, grow up. I mean, really, grow up. You put it out to the world, and you should expect that somebody may collect it. So if they do, just grow up. Maybe they shouldn't. Maybe there should be some limits, but maybe you should have thought about whether you put it out to the world in the first place or not. That which your actions generate without your knowledge. For example, where you are is being recorded moment to moment because you're carrying around a cell phone that's registering on a cell phone tower and that can be used to locate you over time. That's something that we don't really think about, but we can't really function well in society without generating that data. I think that data, you are grown up if you are worried about the collection of that data. Grown-ups should worry about that. And the third bucket of information is that which you communicate intending that you communicate it privately. You're sending an email to so-and-so. You're not broadcasting it to the world. And you certainly don't want the provider who is carrying that email to use it for any purpose, and certainly not disclose it, because you are doing a private communication. That piece of data, I think, grown-ups ought to be really, really, really concerned about protecting the privacy of. So that's how I look at the world in these three buckets. And I'm particularly worried about the second bucket, the data that our actions are generating without our knowledge, without really our consent. It's just because we're going our own way in society. You see more and more that you go into a 7-Eleven, a security camera is recording you. License plate readers are being used by police to create databases about what cars were where, when. I mentioned location information generated by cell phone use. And really, when it comes to the danger to privacy, it's really whether the government is going to end up becoming the great aggregator, the great collector of all this data. It's in the private sector, and guess what? The private sector is collecting it anyway. So really, to my mind, the big question is, what are the criteria under which the private sector can disclose it to the government? When FISA was written, when I looked at FISA, I really thought, this makes sense. It makes sense. You've got this rule that says if it's content, particularly sensitive data, right, content, you have to meet a high standard. You got to go in front of a judge and meet this high standard. And you got to prove that the person is an agent of a foreign power, foreign terrorist group, foreign government, that the person's a spy. You got to prove something like that before you get the content. For non-content, it's a lower standard. But what surprised me after the Snowden revelations was how low the standard was for non-content, for all this metadata, for all this information that we're leaving behind unwittingly that the government can now collect under Section 215. I didn't know that there was such a thing as an investigation to which every phone call made was relevant. That didn't make sense to those of us on the outside who were students of FISA and of intelligence surveillance and of the Constitution. And then I wanted to close with one more thing, and Ben, it goes to your question about rethinking FISA, and Erin, your point about Executive Order 12333. Americans draw protection from FISA, in particular on the content side. It's pretty good. It's probably a good model for other countries. But when you think about what the Europeans complain about and what they're concerned about, Ben, when I go to Berlin, what they tell me is, Greg, how could you, Americans, tolerate and promote discrimination built into your laws? How could you do that? I said, discrimination? What are you talking about? Well, for U.S. persons, it's one rule for people outside the United States. They got to go in front of this FISA court and get a warrant. But for us, all it is that we're outside the United States. You don't know that we're Americans, and we're doing something. Doing something. Oh, that's right, because it's foreign. Any information about the activity of a non-U.S. person outside the United States is foreign intelligence information, perfectly eligible for collection using electronic surveillance and other means. So when I go to Europe, what I hear from those folks is, how could you allow this discrimination and this basically standardless collection of the contents of our communications? Thank you.
Thanks, Greg. And I really like those three categories, the three buckets of information, and this idea of the second bucket of actions that generate the data without your knowledge. I think that is at the heart of the Section 215 issue, the metadata about all of the communications. I don't think individuals really understood that metadata was being Chris, I was wondering if you could unpack a little bit why, it does seem like the section, of all the things that were revealed by Edward Snowden, it seems to me that the Section 215 phone metadata program was the one that when people really took a look at it, they said, this, maybe there is something here that adults should worry about. Could you unpack that for us?
Yeah, I do think that's right. I haven't seen any public opinion polling that sort of grades the different Snowden revelations to see which ones had the most negative impact. But certainly in many ways, the most stunning one was this revelation of what metadata was being collected that was obviously metadata about U.S. persons' communications. All on the telecommunications side, all of the phone records of pretty much, not exclude, they didn't get 100%, but they got a large percentage of the telecommunications phone records, not the content, but the so-called metadata, stretching back 5 years, and they've now got a 5-year database that apparently is a rolling 5 years, so every so often parts of it drop off, but it's a huge amount of information about who's emailing whom and who's calling whom, from which the NSA has this capacity to interrogate this system once they have an identifier of a person who's a suspected terrorist, let's say, to keep it simple. They can then inquire, where has that person called into the United States? And then they can inquire, if the call happened to be made to me, where I have called. And then until the president's limitation of the 2 hops, they could go out one more circle to find out who the person that I called after the terrorist subject had called me had called. And that is justified on the basis of the NSA's belief and the intelligence community's belief that this kind of network chaining provides valuable intelligence information that can be used to construct an investigation or advance an investigation about potential terrorist activities inside the United States. That entire program is predicated legally on a distinction that the Supreme Court made back in the 70s on the difference between private information and information that you had voluntarily disclosed to a third party, as to which the doctrine is you've accepted the risk that that person, even if that person pledges privacy to you, might turn over to law enforcement. And one of the cases dealt specifically with trap and trace kind of information from a telephone carrier. The seminal case was actually involving bank financial records, as to which you immediately have to say to yourself, well, this is a very peculiar definition of privacy. I'm sorry, of voluntariness, voluntarily turned over to the bank, because how else would a business be able to conduct its business unless it had a bank account into which deposits were being made and out of which checks were being drawn and so on. Well, question it you might well do, and I suspect the Supreme Court is going to have the occasion to visit this so-called third-party doctrine sometime in not the too far distant future. They do have the capacity to deduct very important questions, as Irwin's talk yesterday explained with respect to habeas review occurring in the D.C. Circuit. But they have shown an interest in the interface between the Fourth Amendment and technology already in a case involving a GPS tracker a couple of years ago, in which a number of the justices explicitly expressed concern about the third-party doctrine or an interest in revisiting it. So I suspect this is a topic on which the court may speak. Having said that, it has been pretty much accepted law enforcement interpretation of those 70s cases since they came down for the last nearly 40 years, 35 years, that the idea of once you have handed over, or whether or not you know it or not, had an interaction with a third-party commercial concern, bank, telecommunications provider, whatever it might be, and that person has generated a business record about that transaction, law enforcement can access that transactional information without a search warrant and without satisfying the probable cause requirement. And that's the bone of legal contention that is so, it's the constitutional bone of legal contention around which the 215 debate has been focused once it was revealed. There are other legal concerns. One Greg just alluded to, which is just interpreting the statute. How can everybody's phone conversation in the United States be relevant to an investigation? I found that a kind of breathtaking conclusion, and until I read the government's briefs, and I said, well, yeah, I can see how they came to that conclusion. 30 some odd judges have actually agreed with them, and it's Bob Litt has articulated this as you can't search for the needle unless you have the haystack. So unless we have the historical records in a database, once we know there's been a terrorist communication into the United States, we won't be able to find out who that person talked to in the last 3 months unless we've got a warehouse of all of this information that we can then interrogate.
Well, and I wanted to ping you, Greg, also, and maybe ask you a question, but also, why should we care? Like, why you said adults should care, but you didn't really say why.
First, with respect to the haystack, there's a lot of different haystacks that might be useful. My gosh, would a record of everything that everybody purchased on Amazon be useful to stop terrorism? Well, it'd be nice to know who's buying what. Maybe that's a haystack we ought to have.
Don't give the IC ideas.
Well, no, it's just, but my point is it's never ending. Who is where at any moment? That's a big haystack. That's also very useful.
Well, and Greg, I think beyond that, there's nothing that would necessarily, that I know of, stop the intelligence community from just going to the data brokers and buying the haystacks, right? We're just talking about compelling the production of the haystacks right now, right?
And at the end of the day, there is some benefit to those haystacks being only in the private sector. Again, as I said at the outset, a lot of the private sector are collecting this hay in order to make money. They're mining it, and they're developing products and services based on what they're learning from the hay in those haystacks. The question that we have to ask is whether we give all the haystacks over to the government, because the government can do things with hay that others can't. It can use it to not keep an animal warm, but it can use it to figure out whom to investigate, who to wiretap, who to arrest. Google can do a lot of things to you, but usually it's about advertising to you. Google can't throw you in jail.
So, Chris, let's probe that for a second. I'm sorry, Erin, did you have a comment that you wanted to make on that?
I'm sorry, I have to add to that. I like hay. I'd also like to say that a lot of the criticism of 215 that I've heard has been that it hasn't been linked to a specific terrorist plot that was eliminated based solely on 215 telephony metadata, right? So that's the criticism that's out there. But in response to that criticism, and I think it's also responsive to what my fellow panelists have been saying, is that there's a different way to investigate things. When we're investigating for a law enforcement purpose, we're looking at a crime that's occurred, and we're looking backwards to see, we're looking at what happened and how it happened, right? But when we're doing a foreign intelligence investigation, you have to look at what might happen or what we're trying to prevent from happening, which is a completely different way of looking at information than it would be if it was a law enforcement purpose. And one of the reasons why the Patriot Act in Section 215 were created was in response to 9/11. Let's not forget that as well. In 9/11, there was a lot of criticism on the U.S. government for failing to observe a link between a known terrorist and a person who was involved in the plot in Los Angeles, California, somewhere in California, I can't remember. But that was part of the criticism. And this Section 215 was in response to that criticism of, well, then we need to be able to link those folks. And while Greg's ideas are right, I think in terms of we do need to evaluate if as an American society we want the hay. Do we want all this hay and to be able to query it, or are we more concerned about privacy? If we're more concerned about privacy, then our lawmakers should legislate in that direction. But at the end of the day, you can't have both completely. It has to be a balancing factor, and there's no way to have complete privacy and complete national security. It just doesn't work that way. So we, as an American public, need to come up with what balance we think is the right balance for us and for our country.
And so, Chris, I'd like to continue with Erin's thoughts because, so I think, Erin, you articulated very well this capacity that there would be for benefit from having, it's not whether we have the hay or not, I think coming back to the title of the panel, it's where is the hay? Should the hay be in the private sector or should the hay be within the government? Now, the Privacy Review Group, or the Presidential Review Group on Intelligence and the Privacy and Civil Liberties Oversight Board have taken a look at these programs and not seen any misuse of the data by the agencies particularly, but both from the 215 program and the Section 702 data that was obtained. And so, Chris, what's behind this criticism that you hear that, oh, we should keep the hay in the private sector instead of having the haystack assembled back within the government?
Well, the best argument I've heard for separating the data from government auspices and therefore having to have the agency ask for it from a third party was actually on the phone call that we had, that it's a check against mission creep. So if you've got a set of rules and regulations that have to be known to the third party as to what constitutes a valid inquiry, and the certifications are clear enough to the lawyers for the corporation that's going to be reviewing whatever process it is that they're being given, whether it's by the agency or by a court, that is one check against the government deciding that, gee, there's as companies do all the time, gee, there's another business plan that would benefit from our ability to interrogate the data that we've gathered in a new way. Let's try that. If the information is being held by the third party, the government would not have that flexibility until they had gone through whatever revision procedures were written into the law separating the data that would allow its control. There are downsides, though. You're layering in a set of private individuals who are going to be employed by a corporation or entity of some kind, and it's not yet clear what the recommendation, if any, is going to be from the review group that is trying to figure out how to comply with the president's desire to separate this information. He has said that's what he would like to do, get it out of the government's hands, and so far there hasn't been a specific proposal as to how that would be done as a practical matter. And I think creating another holding cell that is outside of the controls that are currently in place, and I ratify what Erin has said about those internal controls. It's really very difficult. I would say it's post-Snowden now, since that hole has been plugged to a considerable degree. Other than, it's very difficult to access this information at all. I would say it's impossible to access the metadata program without having the complicity of multiple parties. Just one individual can't get away with it anymore, is my understanding of the way the system has been operated. So you have an elaborate set of internal controls. You'd have to be sure that the third party had just as an elaborate set of internal controls. And setting up yet another party would concern me. But for this, I think this valid point that Greg has made about protecting against mission creep.
Let me suggest an alternate model. Here's the model that is being talked about in Washington. Does all the records of everyone's phone calls need to be held in the private sector, or should it be held by the government? I don't think that's quite the right question, because that takes us down this road of ordering society around surveillance needs. And that's not the way we've done it traditionally in the United States. What we do is we order surveillance around what society is doing. So we shouldn't be assuming that all this data should be collected, particularly for a program that hasn't been proven effective. Both the review group and the PCLOB couldn't find instances where the data were used to identify a potential terrorist or to stop a terrorist plot.
And they did find that for 702, so it's not as if they're making
right,
that criticism of
right,
all programs.
right,
It was specific to this.
But just to finish this thought, it's that perhaps the data ought to be collected by the private sector and held by the private sector only for the business reasons of the private sector and then disposed of. And perhaps Congress ought to say something along the lines of, don't hold it any longer than X, because if you keep holding it, it's vulnerable to the bad guys, and we don't want the bad guys to get this data. That, and then when the government has suspicion about a person whose data might be in that haystack, it applies for an order to a court and gets the data about that person. That's the model that we've relied on, and now we're talking about going to a completely different model where we think, well, so we're going to hold everybody's data just in case we need it. And we might hold everybody's data at the government level, or we might hold it at the private sector, but we're going to hold it. And I don't think that's a good road for us to go down. I think we're reordering society around surveillance needs in an inappropriate way.
Erin, if we took the approach that Greg was describing, what would that do to the mission?
Well, data like this, while you can't say that one piece of information that was gleaned from 215 foiled a terrorist plot, that's not the way this process works. What we're talking about really is a puzzle. It's a massive 1,000-piece puzzle with pieces everywhere, and this is one piece of that puzzle that allows the intelligence community and the U.S. government to create a picture of what the terrorists are doing. And so it's just one piece of a whole form. I think with what Greg's saying, that it could impact mission if we didn't have access to that data, if we didn't have the haystack. I know he's saying that we should keep, the discussion shouldn't be around, does the government hold the data or does the private corporation like the telephone company hold the data? But I think that's an important note to make, that the telephone company doesn't want to hold the data. They don't want to retain this data. Private sector doesn't want to retain it because the costs associated with retaining large amounts of data is extreme. The additional procedures associated with querying the data when necessary take time. And so I don't know that that's all going to be a good solution either.
That's great. So we could keep going like this, and we actually have some other things other than the 215 program we want to go to, but I wanted to pause here to involve the audience. Do people have questions at this point? I guess there's a few questions. Do we have microphones? Maybe we could start with Professor Schanzer.
As a former Department of Defense employee, I'm surprising myself at kind of attacking Greg from the left. But I wanted to talk about bucket one. You have in your title democracy, freedom. Should there be some restraints on what the government can do with essentially First Amendment protected activity on the web? So my hypothetical is it okay for the government to essentially be scraping Twitter, Snapchat, whatever, looking for certain code words that they might interpret as being indicative of somebody going to engage in violent extremism? Is it okay, given my talk yesterday, to have the FBI looking for people who are saying that the United States is at war with Muslims?
This is such a good question.
And Greg, as you tackle it, could you also say, would it be acceptable for the American people if the intelligence agencies didn't use information that was freely out there that anybody could find on Google to stop a terrorist attack? Maybe take both of those.
There's that, but I would ask this other question. Is it acceptable for the FBI agent in the field office in Washington to read the newspaper and to look for information in the newspaper about who might be doing something that they need to investigate? And would it be acceptable for the FBI agent who just read that newspaper and he saw a name that was interesting for a reason to go do a Google search on that name? I mean, at some level, there is going to be this collection of information. Yeah, I wouldn't want it. I wouldn't want the government to be scanning every Twitter feed. to be looking at every Facebook post that was public. But I think in reality, if you're talking about what's the lesser evil, I'd rather they were doing that than reading everybody's private communications.
And there are other controls in place, right? Just because you would have the ability to access it doesn't mean the government can then use that data in any way possible. So this, once again, I think gets to the question of what
But you
should
get to a
adults really worry
chilling
about.
effect question is if the government, and matter of fact, the Privacy Act does prohibit the creation of files of individuals that are based exclusively on their First Amendment activities. So I'm just wondering if there are or there should be, limits on law enforcement or intelligence looking at those materials on a routine kind of basis.
So I think that the answer is that there ought to be limits, and that the limits are tied to what is permissible in an investigation. You open an investigation under a relatively low standard nowadays. But on the other hand, I do, when this first came out a few years ago, way before Twitter was even popular, and because the Attorney General changed the guidelines that govern FBI investigations, and there was a particular change that dealt with information that was posted publicly on the internet. And they said, basically, we're going to start monitoring this. And we're going to start looking for data that might be used to open investigations. I keep coming back to that newspaper analogy, and it concerns me about somebody failing to read the newspaper and see something obvious that they should have reacted to. And it's the same way for stuff that's publicly posted.
And there are some protections, particularly I think David was mentioning some, but also 12333 has restrictions or protections for civil liberties, and Presidential Policy Directive 28 has protections for civil liberties, correct?
Really, they're very weak, and particularly on the collection side. When you look
on the collection side, definitely.
When you look at what can be done under 12333 in particular, collection is very broad. So
this really gets to the question, Greg, don't you think, of how much should we really be worried about the collection versus the use of the data?
Sure, and at the end of the day, if it's not collected, you have a lot less to worry about when it comes to use.
That's a good point. Let's keep going with questions right here in front.
Thank you. Russ Kilpatrick. I'm a physician. One of the areas that you haven't talked about very much at all that I think is very much a part of this discussion is that in the last, especially the last 10 years, first incentivized, now mandated is the electronic health record. Now, there exists a wall called HIPAA, which is supposed to protect our medical information, but I would suggest that HIPAA is a fairly strong wall if it's going to be used to prosecute me for inadvertently or intentionally releasing health information to somebody in the private sector. But that wall is much thinner when it comes to protecting the medical data from the government. And oh, by the way, anybody who's over 65, there's a program called Medicare, and if you're under 65 and you're under the Affordable Care Act, the government already owns access to everything in your health record. Virtually everything you've talked about, with the possible exception of Twitter's and consumption patterns, is in your electronic health record. I collect data for the government, 2 to 3 hours every day, and put things in your electronic health record that is potentially sensitive information, and as I said, intensely personal. Don't you think the electronic health record needs to be a part of this discussion, both broadly and specifically?
Anybody on the panel want to take a crack at that?
I would say sure. Absolutely.
I'm shocked.
Absolutely. Now, listen. There's a lot in HIPAA about what these covered entities can do with health data that they collect. And there are some good protections there. But there aren't good protections for what non-covered entities can do. I mean, don't get me wrong. I think we would say that the protections that apply for covered entities aren't strong enough. I don't think there's a question about that. And I also, when I go to the doctor and I fill out that consent form, I always wonder what I'm consenting to. But I know that if I don't fill it out, I'm not going to get served, so I fill it out. But what I noticed in HIPAA was how low the standard was for law enforcement access to the data that's being collected. You know, it's medical records. You'd think that of all the statutes that there are, all those privacy statutes, there's like 6 or 7 of them that protect different pieces of data. That would be the one that they would say, well, for this data, we're going to require a warrant. No, it's just relevance. And it's not a government order at all. It's an administrative process. So that really surprised me. That really concerned me. What's the one statute, the one privacy statute that actually requires a warrant for information that wouldn't be regarded as content? There's just one of them. It's not your financial records. It's not the credit records. It's not your driving records. There's statutes that cover those. It's the video rental records. That's the one.
Members of Congress are very concerned about people knowing the videos that they watch. Let's keep going. Right there in the glasses. There you go.
Bill Wells. Is there, and if not, should there be a distinction between information the government gets because it's the government coercively and that which it simply purchases by using their impact card and saying, we want this report? I mean, there's a lot of data out there in the commercial sector, and you know, if a government agency has a use for it and just purchases that, how is that different than, if at all, that they acquired the same property by force and law?
So I'll take that first, since when I served on the Department of Homeland Security's Data Privacy and Integrity Advisory Committee, which Greg now serves on, we actually wrote a paper on this because there were several DHS proposals to do just that and procure data from the private sector. And the conclusions of the advisory committee at that point in time was that there were a need for specific and new controls in an environment like that, and an understanding of transparency. And that was many years ago, and I think our understanding, as Professor Schroeder was mentioning earlier, about the extent of information that is out there and held by data brokers, as was highlighted by the FTC's data broker report, do call a need for some analysis and attention to that. Professor Schroeder, do you want to expand on that at all?
No, not, except to recapitulate what you said. I think there are very few controls, and there are more that are, this is an area that I think ought to be examined, and if Congress would ever get around to actually thinking about policy, this is something that there'd probably be some bipartisan consensus about. But
yeah, and I would say, and Greg, I don't know if you have a comment on this, that Greg's 3 categories, I think, are the right 3 categories, but there's a piece that's not completely apparent, I think, from those 3 about there's a whole set of information that's information that other people provide out to the world about you. So it's not coming from you. You don't know that it was out there in any way. Somebody observed you doing something. Somebody wants to tell a funny story about something that they think that you did before. And now that information is making its way into data broker reports. And I think those things those do fall into probably categories 2 and 3 of what you said. But then when that finds its way publicly and that entities can get access to, I think it does create new types of concerns. Greg, do you agree with that?
I do. Yeah.
All right. More questions? How about way back in the corner back there? Sorry. Keep going around. Sorry, Brianna.
My name is Sarah Williamson. I'm a 1L here at Duke Law School. And I think, we don't have a lot of recent statutory and regulatory law on point where new technologies are concerned. So I think a lot of the reasoning that we see in the courts is reasoning by analogy when trying to apply current law to these new technologies. A few examples that I can think of, when you're decrypting data on a laptop, is it like breaking into a safe with a key or with a combination? Something that Intel has experience with is a server like real or personal property. Is a GPS tracker, to what extent is that like having a human tail? And so I'm wondering, do you think that this approach of reasoning by analogy can ever successfully balance the national security and privacy interests? And if not, do you think there's a better approach, given that, I don't think we will ever have a lot of regulatory and statutory law in this, certainly not that which successfully keeps up with the pace of technological development?
Great question.
Well, that is a good question. Let's take a first cut at it. I think it's logical to start our examination of whether particular activities in the internet world, in the digital world, are appropriate by analogy. I think that's logical. It's something that we are comfortable with as humans. It's something that lawyers are very comfortable with as legal reasoners. I don't know if it will serve us much longer, though. Things have moved so far, so fast, that the analogies, maybe they're just not good enough. And I just think back on the Smith v. Maryland case, and then compare it. Smith v. Maryland, that's the case where the government successfully argued that which you convey to the phone company when you dial digits on a phone, that's information that you have no Fourth Amendment interest in. And what Justice Sotomayor said in the GPS tracking case was, I don't think that this third-party doctrine that says when you convey that information, you have no Fourth Amendment interest in it, I don't think it's serving us anymore. And so what she's inviting is some new thinking. And maybe she's saying to us, let's not just think by analogy to what the old world was, but let's start looking holistically at the world that we want to live in and start describing it with law. And I think that we need to move there.
So I'll just add a point. I think with respect to reasoning by analogy, first thing I want to say is I feel your pain. But I think it's an artifact of the way the human mind works. Members of Congress reason by analogy. Staffers reason by analogy. So this is, until we come up with a conceptual scheme that is brand new and makes sense to people, I think we're going to appeal to the standards that have been laid down by cases in much more primitive times, and the debate is going to be about whether the analogy works or not. So the 215 case is a classic example. Judge Leon decided that that program is unconstitutional. Judge Pauley in New York, Judge Leon in D.C., Judge Pauley in New York, a couple weeks later, decided it was obviously constitutional. They were both in the grips of analogies. One saw the straightforward analogy, straightforward, I don't want to be tendentious about this, if Judge Pauley saw this as an easy case. This is Smith versus Maryland on steroids, but it's still Smith versus Maryland. This is trap and trace information. What's the issue? Judge Leon saw a difference in the quantity of the information and the amount of knowledge it gave the government when it could just do so much more with 5 years of very much more fulsome data, and saw that the analogy no longer extended, and then fell back on the principles established by the Katz case as to whether this violates a reasonable expectation of privacy. So we're in a period of flux. The justices on the court are in a period of flux about this. But I think reasoning by analogy is the way the human mind operates until such time, and it will appear to be in flux, and the analogies will be debated until such time as the dust settles and we come to some intellectual and policy consensus on what the operative analogy will be. And then when technology changes, we'll be reasoning by analogy again.
I would agree with that. And first, I would encourage you, if you're going to ask questions like that, we hope you'll take our class next year when you're at 2L. But I would also say I don't think we have a problem with the fact that we're using analogies. I think we have a problem that we're not using analogies well. And it's a problem with the depth of the thinking. Take the Miller case, which is the banking records case, and the third-party doctrine. Well, if you're going to look at a bank and you want to extrapolate things out from that, you could compare the providing of business records to the bank, but versus locking something in the safe deposit box, which has a whole nother level of whether you actually think you're holding whatever is in that safe deposit box out to the entire world. I think their analogies are there that can be helpful. We just need to spend more time deeply thinking about them. So I know we've got a question here in the corner, and then we'll go around. And I want to ask the panel, to the degree that we can, I do think some of the cybersecurity information of what's going on currently in the environment is important for this purpose. And so if we can build on some of these questions by addressing what's going on information sharing, for example, that would be great. Go ahead.
So, Mike Schmidt, and for the purpose of this question, I'll be from the University of Exeter in the UK. With that, and it's a question for Erin. I was struck by this panel because I've attended many panels with almost exactly the same title abroad, at Leiden and Melbourne and so forth, and the discussion would have been very, very different. It would have started with international human rights law, and then it would have evolved into a discussion of how that law is implemented in regional regimes and domestic law. So you would have started with the broad principles. But today I haven't heard about human rights law at all. So the question is for you, Erin. Does the U.S. government ever talk about international human rights norms and with respect to collection activities, both here and abroad? And if so, what principles do you focus on? Is there a principle of privacy? Do you have discussions about extraterritorial application, effective control, and so forth? Or is the discussion always exclusively about U.S. law?
The answer to that is yes. We do consider those things. We do consider international human rights law. We consider the philosophies behind it. We consider, I think it's safe to say, I think it's fair to say that all countries that I'm aware of, without doing a studious review, have different requirements and different protections for citizens of their own countries. So that's certainly something, since you're from the UK, sir, that's certainly something that while we give additional protections to people with U.S. person status, there are, that doesn't mean that there's no protections for those with foreign status of whatever flavor we were discussing. So I don't know if I can get into too much more to answer that question and specifically what we look at. I hope that answers it.
Well, and I think just to add on a bit, and we can pick this up afterwards if you want to come up, I think there was potentially a false choice there of saying, how come we're not talking about international human rights law? How come we're talking about U.S. law? Which presumes that some of the U.S. law that's built up around this area, particularly about the collection of personal data, wasn't based on some of the same law that some of the international principles that were originally then codified into the OECD principles around the collection of personal data back in 1981. At that time. So I think we shouldn't necessarily say, oh, because we're only talking about U.S. law, we're not talking about international human rights law when we're talking about the collection of personal data. I think the collection of personal data is a unique situation where, to the degree that that's been captured in human rights law and in the different European conventions around this, it tends to come from the same principles that were actually originally articulated here in the United States as applying to the government's collection of personal data. Greg, you may disagree with that slightly.
No, I honestly, David, I'm really coming back to David's point in the back of the room there, and it's just really bothering me. Whether we want this world where the government is listening or watching everything that people say on Twitter or post on the internet, and the more I think about it, the more I think we don't want that world, because you're right, it does chill expression. But I'm trying to articulate where the balance is between what they can collect up front and what they have to ignore. And I'm having trouble doing that. What I think we need to think about in particular are the minimization rules. How long can you hold it if you see it? And then the retention rules. If you see it, when do you hold it? What do you actually retain from your observations?
Hey, Greg, could you describe that just briefly, and it may be difficult to do this briefly, in terms of what's going on with CISPA and cybersecurity information sharing? Because I think it's the same issue.
So CISPA is a bill that was introduced in the House. It went through the House last year. It's what Congress is trying to decide to do is to allow companies in the private sector to share these cyber threat indicators with the government and with each other, which sharing is constrained currently by some laws. So, for example, the Electronic Communications Privacy Act says that a company a Google or a Microsoft, it can intercept, use, and disclose information to protect its own network. But it doesn't say that it can do those same things to protect the networks of others. So there is this problem that needs to be solved. Our concern is that the way that the Congress is going about solving it is going to create other problems. So instead of just fixing that statute or fixing HIPAA to the extent that it inhibits the ability to share information for cybersecurity reasons, they've taken this approach where they're going to say that you can share information notwithstanding any law, without saying what these laws are, without giving a chance for a debate about what's permissible and what isn't, what ought to be preempted and what ought not to be. So we're going down this dangerous road. So when you go down a dangerous road, you try to put in other protections to make sure that you don't run off the road. And so some of the debate has been, should a company be required to remove personally identifiable information from records before they share them with the government if that personally identifiable information isn't necessary to describe the threat? And companies might say, and some do say, well, that's just going to make it so we never share anything.
Or we don't know how to define it.
We won't know
how to implement that
Right.
without you giving us minimization procedures like are imposed upon the NSA coming from the Department of Justice.
Another issue that's come up is once the information goes into the government, say it goes into DHS where we think it ought to go, if it's going into the government, what happens to it? And the way the Senate bill that you'll see on probably Thursday of next week, the way that's crafted is it goes everywhere. If you share with one agency, that agency must share these indicators with a list of 8 other appropriate federal agencies that include DOD, which includes NSA and Cyber Command. So you share with one, you're going to be sharing with all. What does that mean for a company that after the Snowden disclosures promised its users, we will not voluntarily disclose information to the NSA? What does it mean for that company? It means that company can't help. They can't play. They can't share cyber threat indicators because they know they will immediately be shared with all these other entities. The other issue, or one of the other issues that has come up that has been particularly difficult is, there's 2 more. I'm going to go through them real quick.
Yeah, that's good.
When the information is shared with the government, how can it then be used? We're preempting all laws in the service of cybersecurity. Our view is if it's shared under that regime, it should be used for cybersecurity. We would say that prosecuting the hacker, that's a cybersecurity use. But once you go outside of that, then you're talking about a surveillance program. So the Senate bill right now in draft form, it says we can use it for this list of many, many crimes. They're mostly serious crimes, but we can use it to investigate any of those. We can use it to prevent harm to a minor. We can use it for a whole list of reasons. We can use it for any terrorism purpose, which is very broad. So what I think would happen if this got through would be all this information would be put into a pool and then mined over time for these other uses. And the last issue that I think Congress has to wrestle with is the issue of countermeasures, which isn't really a topic of this conversation, but was certainly relevant to conversations earlier today. To what extent can a company that has suffered a cyber attack respond in a way that has effect off of its network, on data off of its network? Can it encrypt data that was stolen from it? Can it encrypt the data around the data that was stolen from it? To what extent can countermeasures have extra network effect? I think that's one of the other issues that will be.
And one of the reasons why I wanted to make sure, and I think it's a good way to close, is traditionally what we've been looking at, and if you look at a lot of the data that was obtained under Section 215 and Section 702 of FISA, it was obtained from traditional telecommunications, phone conversations, that sort of communications. We now have an environment where there's a lot of other entities that sit between your fingers and the end provision of the information on the internet back to you who get a lot of information about you. All of those organizations might produce cyber threat indicators back to, and supply information back to the government. This is not going to be an easier conversation in the future. It's going to be more complicated, and we wanted to get that out. So I want to thank the panel very much.
Well, thank you very much, Dave. And yes, I am going to take your and Chris's class. I think it's a good illustration of, I think this panel, and especially your final remarks there, Greg, of how rich this area is. And in addition, I think it illustrates that a lot of people think, oh, if you're interested in national security law, it doesn't have anything to do with business. It's only for people going to the military and government. I think this demonstrates that there is no business in the 21st century that doesn't have an interest in the very kinds of, and responsibilities, very kinds of things this panel talked about. And I got to say, Erin, that was the best summarization of the statutory architecture of surveillance that I personally heard. And there's a lot of Duke students who are going to be watching this to hear that summarization. And just the thing that you raised in the very end about countermeasures, Professor Schmidt's written a very important, interesting article on that very issue, and I'm hoping that in the fall we can get folks back here and maybe do a panel on countermeasures, because I think it's the hottest issue, right? One of the hottest issues in cyber right now. The scope, exactly what it means, and so forth. Be that as it may, we are going to take a break here till 11:15 and maybe a minute or two afterwards. I did want to let you know that Harvey Rishkov can't be with us. He's going to be with us. He can't be with us physically. He's going to be with us electronically for the ethics presentation. And as we saw last night with Senator Graham, that does work pretty good. It is going to be interactive, and I'm looking forward to hear what Harvey has to say. And I did want to mention my friend Bill Wells. He has a very interesting listserv, and he kindly allowed me to mention that. And so if you want to start getting Bill's listserv, he's right there. And then finally, this, I think, has a record for the most general officers attending a conference. There are 6 active, that I know of, 6 active and retired. I'm seeing Pete Maschiola over there in disguise, I might add. I don't know whether he's with another government agency now wearing his beard, but he is a retired general officer, I will tell you that. Thank you very much. And again, fantastic panel. Really, we've had great Saturday morning sessions, but between Ben and this panel and what we're going to get from Harvey, I think we're at the very top of the echelon there. Thank you very much.